Alright, eligibility procedure registration of apprenticeship program. Eligibility registration for the apprenticeship program vary for the federal purposes for the condition upon with the program's conformity with the apprenticeship program. Standards published in this part of the program is determined with the secretary being in conformity with those published in standard with the program must apply with the registration registered with the office of apprenticeship with the state of the apprenticeship agency recognized with the office of apprenticeship with the determination of the secretary of the program means that the apprenticeship program standards effectuated only through the such registration. B. Only the apprenticeship program and the agreement made with the following criteria of eligibility of the Office of Apprenticeship and the State Apprenticeship Agency registration is conformity with the requirements for this part with the training with the apprenticeship with occupation with having characteristics set with Ordinance 29.4 with this part is conformity with the requirement of the Department of Regulation Equal Opportunity of the apprenticeship and the training 29 CFR to Part 30 with as amended. Except as provided on the paragraph D of this section, experienced apprentices must be individually registered under the registered program, and individual registration may be affected. Final copies of each of the individual apprenticeship agreement with the registration agency subject a prior office of apprenticeship recognized state and apprenticeship agency approval by the filing the master copy of such agreement followed by the listing of the name and the other required data for each of the individual apprenticeship. The names and the person for the probationary element is employment is an apprenticeship for the apprenticeship of the program registered with the office of apprenticeship and then the registered estate with the apprenticeship agency. If not, an individual registered under such of the program may be submitted within 45 days of employment. Office of apprenticeship and state apprenticeship of the agency for certification to establish apprenticeship is eligible for the probationary employment. Appropriate registration and agency notified within 45 days of the person who has successfully completed the apprenticeship program, the transfer, the suspension, and translation of the apprenticeship. Agreement is the same with the region of the operating apprenticeship program with the approved with the office of apprenticeship are recorded with the registered events of evidence of the certificate of registration programs received by the state apprenticeship of the agency must be ordered. The registration approval evidence is similar with the certificate other written indica when approved with the office of the apprenticeship national apprenticeship guidelines standing for the policy for the guidelines will be according with the certificate. Application for the new program, the registered agency determined that the meet of the required standard for the program and the registration must be given them with the provisional approval within the period of 1 year. The registration agency must review all the new group programs of the quality for the conformity with the requirements of the part of the end of the first year of the registration at the time. 1. The program of the conform with the requirement of this part. 2. The made with the made to be may be made permanent. 3. 2. May continue the following provision with approval of the first full-time training cycle. The program not operating with does not conform with the regulation during the provisional approval period must be recommended for the deregistration procedures. 8. The registration agency review of all the program's quality for the conformity with the requirements of this part of the end of the first full of the training cycle. The satisfactory review of the provisional approval of the program will result in the conversion of the provisional approval of the permanent registration. Subsequent review for the must be conducted with not less than frequently than every 5 years. The program is not operating in no conformity with the regulation must be recommended with the deregistration procedures. Alright, any sponsor for the proposal application for the modification change for the registered program certified with the national guideline for the apprenticeship standards must be submitted with the registration agency. Registration agency must make with the determination whether to approve such submission within 90 days of the date of the receipt. If approved, the modification and change will be recorded with the knowledge within 90 days of the approval as amended with the selection program. If approved, with the sponsor must be notified with the disapproval in the region, therefore, but provided with the appropriate technical assistance. J. Under the program proposed with the registration employer standard association with the standard collective bargaining agreement, the other instruments provided with the participation by the union and manner of the operation of substantial matter of the apprenticeship program, such for the participation exercise written with the knowledge of the union agreement. No objection with the registration required, where there is no such participation evidence practice for the employer. The employer association must simultaneously furnish the to an extent with the union to an existing union which is collectively bargaining agent for the employees to be trained and copy of the application for the registration of the apprenticeship program, and the registration agency must provide the receipt with the union comments if any of the 45 days by the final action or in the approval of the registration and application for the registration and approval. Where the employees to be trained with the non-collective bargaining agreement, the apprenticeship program may be proposed as registration by an employer group of the employers or employer association. Statute 29.4 criteria for the application apprenticeship Apprenticeshipable occupation. Apprenticeshipable occupation is one which must be set unspecified with the industry and must be involved with the skill to customarily learn a particular way through the structured systematic program of on-the-job supervised learning to be clearly identified and commonly recognized throughout the industry, involving the progress attained with the manual, mechanical, technical skills, knowledge, which, in accordance with the industry standard for the occupation, will require completion of at least 2,000 hours of on-the-job learning of to attain the required the related instruction of supplement on-the-job training learning. Standards Apprenticeship Program. The Apprenticeship Program, 29 Statute 29.5. An apprenticeship program to be eligible for the registration agency must conform with the following standards. The program must have the organized written plan with the program standards aligning with the terms, the condition, employment, the training, the supervision of one or more apprenticeship of the apprenticeship occupation as defined and part of the described by the sponsor who is undertaken to carry out the apprenticeship training program. When the program standards must contain with the provision for the dress, the employment, the training, and the apprenticeship of the skill of the occupation, the term of the apprenticeship with the individual apprenticeship that may be measured to enter either through the completion of the industry standard for the on-the-job learning, or at least 2,000 hours or time-based approach with the attainment of the competency-based approach, or blend of the time-based and competency-based approach in a hybrid approach. When the time-based approach measures for the skills of acquisition for the individual apprenticeship completion with at least 2,000 hours of on-the-job learning with the described the work-based process schedule. 2. The competency-based approach measures for the skill acquisition through the individual apprenticeship. Successful demonstration of acquired skill for the knowledge verified by the program. The sponsor for the program utilizing the approach must still require the apprenticeship to complete on-the-job learning components with the registered agency for the program standard, but they may address on how on-the-job learning will be integrated with the program describing the competency and identifying the appropriate means for the testing and evaluation for the sum of the competencies. 3. The hybrid approach measure for the individual apprenticeship skill through the combination of the specified minimum number of hours and learning of the successful demonstrated competency describing the work process schedule. 4. The determination for the appropriate approach for the program standard made by the program sponsor, subjects approved by the approval of the registration agency of the determination approach for the apprenticeship occupation for which the program standard is registered. 3. An outline of the work process in which the apprenticeship will receive the supervised work experience training over on the job, the allocation of the approximately amount of the time to be spent in the major process. 4. Provisions for organized related instruction technical subject of the occupation, a minimum of 144 hours each year of the apprenticeship is recommended, but the instruction techniques subject that may be accomplished through media in such classrooms, occupational, industrial courses, electrical media, and other instructions approved by the registered agency and apprenticeship registered agency. Every apprenticeship instructor must meet the State Department of Education's requirement for the vocational technical instructor in the state registration, or be subject matter expert with an individual such as a journeyman worker who is recognized within the industry having expertise of having specific occupation. 2. Have a training in the techniques and adult learning styles which may occur before and after the apprenticeship instructor has started with the provided before or after the apprenticeship instructor has started to provide the related technical instruction. 5. A progressively increasing schedule wages to be paid with the apprenticeship consistent with the skill of the acquired, but the entire wage must not be less than the minimum wage prescribed by the Fair Labor Standard Act, where applicable, unless the higher wage required for the other applicable federal state law with the respective regulations or collective bargaining agreement. Periodic review and evaluation of apprenticeship performance for the job and then related instruction for the maintenance of the appropriate records. A numeric ratio apprenticeship with the journey work consisting of the proper supervision, training, safety, and continuing of the employment and application of the applicable provision of the collective bargaining agreements, except with such ratio expressly prohibited by collective bargaining agreement. The ratio language must be specifically and clearly described as to the application of the job site workforce department and plant. 9. Probationary period of reasonably relation for the full apprenticeship. The term of the full credit given with such a period toward the completion of the apprenticeship. The probation period cannot exceed 25% of the length of the program, 1 year, whichever is shorter. Adequate safety equipment facility with the training of the supervision, safety training with the apprenticeship with on the job related instruction. 10. The minimum qualification required for the sponsor for the person entering the apprenticeship program with an eligible starting age is not less than 16 years old. The placement of the apprenticeship owner with the written apprenticeship agreement meets with the requirements of Statute 29.7 of the State Apprenticeship Law with the recognized registered agency. Agreement must be directly or by reference incorporated with the standard for the program as part of the agreement. The granting of advanced standing with the credit and the demonstrator of the competency, acquired skill, experience, training skills are full. All applicants are equal to compensate the wages for the any progression step granted. Alright, 13. The transfer of the apprenticeship between the apprenticeship program with the apprenticeship program must be based on the agreement between the apprenticeship and the effect of the apprenticeship committee, but the program sponsor must comply with the following requirements. The transfer apprenticeship must be provided with the transcript of the related instruction on the job learning with the committee of the program sponsor. 2. The transfer must be the same with the occupation. 3. The new apprenticeship agreement must be executed with the transfer occurs between program sponsors. Assurance for the qualified training personnel, adequate supervision on the job. 15. Recognition for the successful completion of the apprenticeship evidence by an appropriate certificate issued with the registration agency. 16. Program standards of the utilize of the competency-based hybrid approach progression through the apprenticeship that achieve the issue with the interim credentials, but must clearly identify the interim credentials, demonstrate the credentials linked to the components of apprenticeshipable occupation is established with the process assessing individual appreciation and demonstration. Apprenticeship demonstration competency are associated with particular interim credentials. Further, interim credentials must only be issued for recognized components of the apprenticipable occupation. Therefore, the linking of the interim credentials specified with the knowledge and skills abilities associated with the components of the apprenticipable occupation. 17. Identification of registration agency and 18. Provision of the registration cancellation deregistration program. The prompt of the submission of the name of the program standard with the modification amendment of the registration agency with the further approval. Provision of registration apprenticeship agreement modification amendment with the notice for the registration agency with the person who has successfully completed the apprenticeship program. Notice for the transfer, the submission, suspension, cancellation apprenticeship agreement statement of the reason for thereof. Therefore. Authority for cancellation of the apprenticeship agreement during the probationary period by either party with the state of the college. Cancellation during probationary period will not have adverse impact on the sponsor's completion rate. Applies for the Title 29 Part 30 include the equal opportunity employers prescribed in 2933B and affirmative action complying with the Title 2934. A method for the selecting apprenticeship authorized by 2935 and in compliance with the payroll requirements contained in the state plan for equal opportunity with the apprenticeship adopted in Title 29 CFR Part 30 and approved with the apprenticeship standards may also include the statement the program will include conducted, operated, and administrated with the conformity applicable provisions of Title 29 Schedule of Relation 30 if it is amended if and applicable to provide approved state plan for the equal opportunity of the apprenticeship. 22. Contact information, name and address, telephone number, email address, if appropriate, with the appropriate individual with the authority under the program to receive the process of making disposition for the complaints. Record keeping the maintenance of the records concerning the apprenticeship as may require by the Office of Apprenticeship, recognized state and apprenticeship agencies, other applicable laws. 29.6 Program performance standards. Every registered apprenticeship program must have at least one registered apprentice, except for the following specified the periods of the time which may exceed 1 year. Between the day of when the program registered and the day of the registration of the first apprentice, or between the day of the program graduates the apprentice for the day of the registration of the new apprentice in the program. The registration agency must be evaluated performance of the registered apprenticeship. The tools and factors to be used must include the not limited to the quality assurance assessment, equal opportunity, the compliant reviews, and completion rates. 2. Additional tools and factors used with the registered agency evaluating program performance must be adhered to the goals and policy of the department articulated within this part and guidance by the Office of the Apprenticeship. In order to evaluate the completion rate, the registered agency must review the program completion rate with the comparison to the national average for the completion rates based on the review of the registration agency must provide technical assistance to program with completion rates lower than the national average. Of cancellation apprenticeship agreement during the probationary period will not have an adverse impact on the sponsor's completion rate. 29.7 Apprenticeship agreement. The apprenticeship agreement must contain the explicit reference to the name of the signatures and contracting parties of the apprenticeship within the program sponsor or the employer. The signature parent of the guardian if the apprenticeship is a minor with the date of the birth on the voluntary basis, social security voluntary basis, social security number of the apprenticeship, the contact information of the program sponsored by the registered agency, statement of the occupation with the apprenticeship is to be trained with the beginning of the day and the term of the duration apprenticeship the state of the showing the number of the hours to be spent by apprenticeship then working with the job and the time-based program with the description and skill set with the same completion competency-based program including the on-the-job learning component within the minimum number of hours to be spent with the apprenticeship, the description of the skill to be obtained by the completion of the hybrid program and or by the number of hours to be spent with related instruction technical subject related with the occupation which recommended but not be less than 144 hours per year. The statement of the setting forth of the scheduled work process within the occupation and industrial division which appropriate is to be trained approximately time to be spent in each process. G. The state move of the graduated scale of the wages to be paid with the apprenticeship, whether or not to be required related with the instruction compensated age for the statements providing for the specific period of probation during which the apprenticeship agreement may be canceled with either part of the agreement upon written notice to the registration agency with adverse impact for the sponsor. The fact that after every probationary period of the agreement may be 2 canceled with the request for the apprenticeship, 3 suspended with the cancel with the sponsor for the good cause with the due notice, the apprenticeship with the reasonable opportunity with the corrective action for the written notice for the apprenticeship to the registered agency and as final action taken. Alright, a reference incorporating as part of the agreement with the same with the apprenticeship of the program with the existing date of the agreement after they have been amended during the period of the agreement. J. The same of the apprenticeship will accorded with the opportunity for the pay for the apprenticeship employment with the training without the discrimination based on because of the race, color, and religion, national origin, or sex. Contact information, name and address, phone number to email with appropriate and or with appropriate authority with the national under the NAP program to receive the process of the making the disposition controversy with the difference arising out of the apprenticeship agreement when the controversy difference cannot be adequately adjusted locally and resolved in accordance with the be established and procedure applicable to collective bargaining provisions. Alright, 29.8. Deregistration of a registered program. Deregistration for the program may be effective upon voluntary action of the sponsor submitting the request for the cancellation registration from the corner of the paragraph A of this section upon the reasonable cause by the registration entity instituting formal demonstration proceeding with the accordance with the paragraph B of the section. Entity registration with the request for the sponsor of the registration agency may cancel the registration apprenticeship program by written acknowledgement of such a request of the stating the registration cancel that the sponsor request for the effective date thereof. Therefore, that within 15 days of the day of the acknowledgement, the sponsor will notify all the apprenticeship of the charge for the cancellation effective date of such cancellation automatically deprive the apprenticeship of the individual registration. The deregistration program remove the apprenticeship of the cover the federal purpose, which required by the Secretary of Labor approval of the apprenticeship program that all the apprenticeships are referred to the registered agency for information for the potential transfer to the registered apprenticeship program. Deregistration by the registration agency with the reasonable cause. 1.1 deregistration procedures undertaken with the approximate undertake with the apprenticeship program with conducted with oriented administrative accordance with the program registered provision for the requirements of this part include but not limited to the failure provided with the on-the-job learning, failure to provide the related instruction, failure to pay the apprenticeship does not progressively increase with the schedule of the ways consistent with the apprenticeship skills acquired with the participant, the significant failure to perform successfully the deregistration procedure for the violation of equal opportunity requirements must be processed in accordance with the provision in Title 29, Part 30. The purpose of this section persistent significant failure of the program successfully occurs when the program sponsor consistently fails to register at least one of the apprenticeship show for the pattern of the poor quality assessment results over the period of several years demonstrate ongoing pattern of the very low completion rates and over the period low completion rates over the period of several years show no indication of the improvement of the area identified with the registered agency during the review of the process requiring the corrective action when it appeared that the program did not being operated in accordance with the registered standard with the requirements for this part of the required registered agency must notify the program sponsor in writing. The notice sent with the program sponsored contact person must be sent registered certified with the mail with a receipt and request for the state shortcutting the remedy required with in the state with a determination responsibility cause for the registration will be made with the corrective action the effective day within 30 days. Upon request for the sponsor for the good cause of the 30-day term with the extent within another 30 days during the period of the corrective action, the registration agency must assist the sponsor every reasonable way with achieving conformity. If the record correction is not effective with the allotted time, the registration agency must send the notice for the sponsor registered with the certified mail, which is received and the request for the state of the following. When the notice for the sent under the paragraph is certain deficiency will call the sponsor's attention, enumerating them in remedial process request for the date of such occupation letters, and the sponsor have failed to refuse in effect for the correction based on the state of the deficiency failure to remedy with the determination has been made with the reasonable cause to be deregister the program. The program may be deregistered within the 15 days. The receipt of the notice of the sponsor request for the hearing within the applicable registration agency 4. The sponsor does not request the hearing at any time of the matter with the submitted with the administrative office, the apprenticeship with the decision on record with respect to deregistration. 6. If the sponsor does not request the hearing, the registered agency will transmit the administrative report containing all the pertinent facts with the circumstances confirming the nonconformity, including the finding of the recommendation for deregistration with the copies of all relevant documents and record statement concerning the interviews, meeting with the competent, which include the time, the date, and place and person present. The administrative will make a final order on the basis of the record presented. 7. The sponsor requesting the registration agency will transmit the administrative report containing the data listed in paragraph B6 of the section. Administrative will refer to the matter of the Office of Administrative Law Judge. The administrative law judge will convene with on hearing in accordance with the 2910 issues a decision required with the 2910. Every order of deregistration must contain a provision with the sponsor, but there must be 15 days of the effective date of the order. Notify all the registered apprentices of the deregistration program the effective date thereof. That such cancellation automatically deprive the apprenticeship of the individual registration of the deregistration, remove the apprenticeship for the coverage of the fraudulent purpose, which will require secretary label approval of the apprenticeship program, that all apprenticeships are referred to the registered agency for the information potential transfer to other registered apprenticeship programs. 29.9 Reinstatement of the program. Any apprenticeship program deregistered under the statute 29.8 may be reinstated upon the presentation of adequate evidence that the apprenticeship program is operating with accordance with this part. Such evidence must be presented with the registration agency. Alright, 2910 hearing for the deregistration. Within 10 days of the receipt of the request for the hearing, the administrative of the Office of Apprenticeship will contact the Department of Office Administrative Law Judge to request the designation of the Apprenticeship Law Judge to preside for the overall hearing. The Administrative Law Judge shall be reasonable notice for the such for the hearing. Registered mail will return the receipt request with the appropriate response for the such notice include responsible time and place for the hearing is same with the provision of the purpose of the part of the pursuant with the hearing is to be held with the concise statement of the matter of the pursuant to the action form with the base for the hearing is proposed and to be taken the procedure contained in the Title 29 CFR Part 18 will apply with the decomposition with the requesting of the hearing except. Administrative law judge will receive the part of the record of documentation evidence offered by the party for the acceptance of the hearing. Copy thereof will be made available to the part of the submitting with the documentary evidence with any part of the hearing and upon request. Technical rules and evidence will not apply with the hearing of the conducted for the pursuant with the part of the rules and principles designed to preserve the production of the most credible evidence available and to subject the testimony test of the cross-examination will be applied with the reasonable necessary with the administrative law judge conducting the hearing. The administrative law judge may exclude irrelevant, immaterial, unduly repetitive evidence. Administrative law judge should issue the written decision within 90 days of the close of the hearing. The administrative law judge, the decision constitutes final agency unless within 15 days of the receipt of the decision partly dissatisfied with the decision filed with the petition review with the administrative review board, specifically identified with the procedure fact with the law of the practice and policy with the exemption of the taken with the exemption not specifically urged is deemed to have been waived. The copy of the petition review must be sent with the opposing party. At the same time thereafter, the decision of the administrative law judge remains of the final agency action unless the Administrative Review Board, within 30 days of the filing of the petition with the review, notified the pertaining parties that it has been accepted. In the case of the review, the Administrative Review Board may be set with a briefing to schedule to decide matter of the record. The Administrative Review Board must decide in any of the case except for the review of the 180 days close of the record. If it is not so decided, Administrative Law Judge's decision constitutes final agency action. Statute 2911, limitation. Nothing in this part of the apprenticeship agreement will operate with invalidity to invalidate the apprenticeship program provision for the collection of the program bargaining agreement between the employers and employees establishing higher apprenticeship standards or apprenticeship special provision for the veterans minority person employment for the standard apprenticeship qualification opportunity for the operation of the program in which the apprenticeship agreement which is not otherwise prohibited by law, executive order, or other authorized applicant. Regulation complaints. The section is not applicable to any complaint concerning with the discrimination or other equal opportunity matters. All such complaints must be submitted with the process resolved in accordance with approval of the provisions Title 29 CFR Part 30. Applicable provision for the state plan with equal opportunity in the apprenticeship adopted the pursuant to Title 29 CFR Part 30. Approved the department. We accept the matters described in paragraph A of the section A with the controversy differences arising on the apprenticeship agreement with the cannot be justly locally, which is not covered with the collective bargaining agreement, may be submitted within the apprenticeship of the apprenticeship authorized representative of the apprenticeship registration authority in either federal, state, or which have the registered approved of the program with which the apprenticeship is enrolled with the review. The matters covered with the collective of the bargaining agreement are not subject for such review. See, the completion date must be written and signed with the complaint with the authorized representative. It must be submitted within 60 days of the final of the local decision. It must be set forth in a specific matter, but is combined together with the relevant fact with the circumstances, copy of the pertinent documentation with correspondence must accompany the complaint. The Office of Apprenticeship of the recognized state apprenticeship agency as appropriately will render the opinion within 90 days after the receipt of the complaint based on such an investigation of the matter submitted with the must be found necessary for the record before during the 90-day period. The Office of Apprenticeship recognized the state apprenticeship agency will make reasonable effort to be effective satisfactory resolution between the parties involved. With the result of the parties will be notified with the case is closed, whether an opinion is rendered. The copies will be sent to all the interested parties. Nothing in this section precludes the apprenticeship further pursuing any other remedy authorized under another federal, state, or local law. The state apprenticeship agency may adopt the compliant review with the procedure differing with the detail and the given with the section provided with the submitted review and approval of the Office of Apprenticeship. 2913. Recognition of the state apprenticeship agency. Recognition of the department. The department may exercise the authority of the grant recognition of the state apprenticeship agency. Recognition with the conferred with the non-exclusion of authority to determine whether the apprenticeship program conforms with the public standard, but whether the program is thereof, therefore, is eligible for federal purposes when required with the determination of the department. Such recognition should accord with the state with the submission for the department approval of state compliance with the following state apprenticeship agency may submit with the state apprenticeship law within installed through the statute, executive order, regulation, or other means conform the requirements by the Title 29 CFR Part 2930. The State Apprenticeship Agency establishes continue to eve the State Apprenticeship Council within which the operates with the direction of the State Apprenticeship Agency. The State Apprenticeship Council may either be regulatory or advisory. It must meet the following requirements: 1. Must be composed of a person familiar with apprenticeship occupations. 2. Must include equal number of the representative employer with the employee organization, include the public members with whose shall not number the status of the number of named to represent the employer or the employee organization. 3. The state apprenticeship agency must submit the state plan with equal opportunity in the apprenticeship that conform with the requirements published in Title 29 CFR Part 30. State apprenticeship agency submission must include the description of the basic standard with the criteria requirements for the program registration or approval. Demonstrate linkage to the coordination with the state economic development strategy of the publicly funded with the workforce investment system. The state apprenticeship agency for submission must include the description policy operating with the procedure, which are apart from those requirements additional with those prescribed in this part. Basic requirements in order to obtain and maintain recognition for the provided within paragraph A of this section. The state apprenticeship agency must conform with the requirements for this part to accomplish what the state must 1. Establish, maintain, and administrative entity with the state apprenticeship agency for the capable of performing the function of the registration agency under Title 29 CFR Part 29, provided with sufficient resource for the carry out of the function of registration agency, including the outreach of the education and registration of the program's apprenticeship provision with the technical assistance monitoring as required to fulfill the requirements for this part. 3. Clear delineate the respective power of the duty for the state office of the state apprenticeship agency or the state apprenticeship council. Establish policies, procedure to promote equal opportunity with the apprenticeship program pursuant to the state of the plan with employment and equal opportunity with the opportunity apprenticeship with adopted and implemented for the requirement of the Title 29 CFR Part 30 to require apprenticeship program that operate with conformity with the state plan with the Title 29 Part 30. Prescribe the contents of apprenticeship agreement with conformity with the Statute 29.7 and ensure that the registration of the apprenticeship program occurs with only an apprenticeship occupation that is provided with the Statute 29.4. Include the occupation with a high growth and high demand industries. 7. In accordance with the reciprocal approval with the federal purpose of the apprenticeship program stand with the registered and the other states of the office of apprenticeship with the registration agency and such reciprocity request for the apprenticeship program sponsor for the program sponsor for those seeking reciprocal with approval that must be made the wage for the hour provision for the apprenticeship ratio stand with the reciprocal state. Provide the cancellation deregistration program for the temporary suspension cancellation deregistration apprenticeship agreements and submit all proposed modification legislation, regulation, policy, and operation procedures planned with the anticipated with the state apprenticeship agency either in time application with the recognition or subsequently to the office of apprenticeship for the review obtained with the office of apprenticeship concerning the concurrence with the prior implementation. C. Application recognition. The state apprenticeship agency desire a new condition with the recognition of the registration agency must submit with the administrator of the office of the apprenticeship with the documentation paragraph A with the section of the currently recognized with the state the desire with the continued recognition by the office of apprenticeship must submit with the administrative office of the apprenticeship with the document specified in paragraph A with the section within 2 years with the effective date of the final rule. The recognition of the currently recognized state shall continue for up to 2 years from the effective date of the regulation during the extension of the period of the grant with the administrative extension of the time which comply with the direct requirements for the part may be granted to the administrator for good cause upon written request of the state, but administrative shall not exceed Extend the time of their submission of the documentation required of the paragraph A of the section, and upon approval of the state apprenticeship agency, application for recognition for the name of the subsequent modifications to application required for the under this paragraph B9(6) for this section. Administrator shall notify the apprenticeship agency in writing. Duration recognition of the state apprenticeship agency shall last 5 years within the date of recognition granted under the paragraph C of this section. Administrator shall notify each of the state with the registered agency with at least 100 days prior to the expiration date of the 5-year period with the registered agency is conformity with the part of the based on the review of the conducted by the office of apprenticeship that is required with the paragraph E of the section. The notification state of the state apprenticeship agency is in conformity with recognition will be renewed with additional 5 year if the notification of the state apprenticeship agency is not conformity with a notification shall specify the area of the nonconformity requirement of the corrective action and other technical assistance after the administrative determined that the state apprenticeship agency is corrected. The identified nonconformities recognition will be renewed for the additional 5-year period. Compliant with the office of apprenticeship will monitor with the state registered agency with compliance with the recognition requirement of the part through. On site with the review of the conduct with the office of apprenticeship, the staff is office assessment reports required for the office of apprenticeship 3. Review the state apprenticeship of the agency legislation, regulation, policy, and operating procedure required for the be submitted in the paragraph A1 and A5 and B9 with the section reviewed and approval is required under statute 2913A. Determine whether the base of the review board for the paragraph under statute, paragraphs E1, 2, and 3 with the section for the state registration agency is compliant with the Part 29 note that the state registration agency determined will be given 45 days for the proposed modification, all legislation, regulation, policy, operation, procedure required to submit under paragraph A1, A5, and B9 with the section accountability, remedies for the nonconformity state registration agencies that fail to maintain the compliance with requirements for this part will provide under the paragraph E with the section 1 receive technical assistance from the office of apprenticeship and then after the remedy of the nonconformity activity 2 be placed in conditional recognition for the period of the 45 days for the state apprenticeship agency must submit with the corrective action plan to remedy with the conformity of the action with the office of apprenticeship upon the request of the state apprenticeship agency for good cause of the 45-day period may extend the 2 failure to comply with these requirements result in the rescission of the recognition of the federal purposes provided in statute 2914 deny the state and apprenticeship agency recognition denial of the office of apprenticeship of the state of the apprenticeship agency application for the new continued recognition must be written, must be set forth in reason for denial. Notice must be sent with a certified mail return receipt requested. Additional the reason stated for the denial of the notice must be specified the remedy for the must undertake the prior ordinance consideration for the submitted request and must state the request for administrative review and denial recognition must be made with a 30-day calendar to receive the notice of the denial with the department such that the request may be made with the mail address for the chief administrative law judge for the department, the mailing address for the office of apprenticeship law judge for the U.S. Department of Labor, the Suite 400 North at 800 K Street, North Washington, D.C. 2001, 8002, within 30 calendar days for the filing of the request for the filing, the administrator must prepare the administrative record of the submission. Administrative law judge designating the chief of the administrative law judge. The procedure contained in the Title 29 CFR Part 18 will apply with the disposition of the question request for the review except that the administrative law judge will receive and make the record with the documentation evidence order the part of the acceptance of the hearing. Copies there will be made available to the party submitting with the documentary evidence with any part of the hearing upon request. Alright, 2. The technical rules and of the evidence will not apply with the variance conducted under this part, but the rules and principles designed with the assure of the production with the most credible evidence available to the subject testimony. Since after the cross-examination will be applied whether the reasonable necessary, but the administrative law judge conducting the hearing of the administrative law judge may exclude irrelevant material and unduly repetitive evidence. Administrative law judge should be submitted with the proposed finding with a recommendation decision with certified the record of the proceeding with the administrative review board within 90 calendar days after the close of the record. Within 20 days of the receipt of the recommended decision, any part of the may file exemptions and the department may file with a response to the expectations and another party within 10 days of the receipt of the expectations. All exemptions and the responses must be filled with the administrative review board with a copy of the served on all parties in a Amicia Curie. Art 4. After the close of the period, final exemptions and response to the administrative review board may issue the briefing schedule to decide the matter of the record, and administrative review board must decide at any case of the review that 180 days closed for the record. If not so decided, the Administrative law judge decision, the consistency of the agency action, the decision of the Administrative Review Board constitutes the final action department. 8. Withdrawal of the recognition of state apprenticeship agency, voluntary relinquish for the recognition of federal purpose, state purpose, a formal notice with the intent of the administrative office of apprenticeship to provide all apprenticeship program standards, apprenticeship agreement completion record for the cancellation, suspension records, equal opportunity compliance review, and files any other document relating to the state apprenticeship programs of the department, cooperate fully and during a transition period, retention of the authority, nothing but the name of the grant recognition for the state apprenticeship agency under the section of the office of apprenticeship retains the full authority to register the apprenticeship program and the apprenticeship in the state and territory of the office of apprenticeship to determine with such action if it is necessary to further interest of the national apprenticeship system. State apprenticeship program and an apprenticeship program submitted with the state registry agencies registration must be federal purpose to be in conformity with the state apprenticeship law of regulation, state plan with the equal opportunity within apprenticeship submitted and approved in the office of the apprenticeship pursuant to Title 29, Part 130. In the event of the state of the apprenticeship agency is not recognized by the office of the apprenticeship for the federal purpose with such recognition have been withdrawn, no state with the apprenticeship agency exists, the registration of the office of the apprenticeship may be requested, such that the registration must be granted with the program conducted with the administrator operated in accordance with the requirements of this part, equal opportunity regulation, Title 29 CFR Part 30. Alright, 2914, derecognition of the state apprenticeship agency. The recognition of the federal purpose of the state apprenticeship agency with withdrawal and the failure to fulfill the operate with conformity with the requirements of Part 2930. Derecognition procedure responsible for the conduct of the institute with accordance with the following derecognition procedure for the failure to adopt it promptly and enforce with the state plan equal opportunity. The apprenticeship must be procedure in accordance with the procedures prescribed in 29 CFR Part 30. For the conduct other than those under the paragraph A of this section, the office of apprenticeship must notify the respondent and with an appropriate and stated sponsor in writing of the certified mail with the receipt with the return receipt requested. Notice must set before the following the reasonable cause of the existing belief that the respondent has failed to fulfill the operative with conformity with the requirements, specific area of the non-conformity need for the remedy measures, and the office of apprenticeship of the programs withdrawal recognition federal purpose unless corrective action taken on a hearing request mailed within 30 days of the receipt of the notice. See if within the 30-day period with the state apprenticeship agency acknowledgement of the state is out of conformity specified for the proposed remedial action commenced for the itself with the remedy of the identified with the deficiency with the office of apprenticeship will suspend with the derecognition process with the allowable the reasonable period of time state apprenticeship agency's implementation of corrective action if the office of apprenticeship determines the state corrective action and addressed and identified with the concerns. Office of apprenticeship must notify the state within the derecognition procedure with the determinated. 2. If the office of apprenticeship determines the state has not addressed the failed the remedy identified with the concern with the administrative notify the state in writing of its failure, specifying the reason therefore the office of the state and opportunity request the hearing within 30 days. Failure to comply request the hearing of the office of apprenticeship shall decide with the recognition shall be withdrawn. The decision in the affirmative the administrative that must begin with the process of transfer of the registration. Paragraph D. The request for the hearing of the administrative shall refer to the matter of the office of administrative law judge. Administrative law judge will convene the hearing with accordance with 2913 with the submit of the proceeding filed with the recommendation decision with the administrative review for the final agency with the vote action for the administrative review must decide any for the case with the except with the review for the 180 days with the close of the record. If not so, to decide administrative law judge with the decision constitute with the final agency action. If the administrative review board determines withdraw the recognition for the federal purpose of the office of apprenticeship that has decided the recognition should be withdrawn with the paragraph C2 of this section, administrator must 1. Notify the registered agency state sponsor with the withdrawal of the effect of the public notice with the withdrawal. Notify the sponsor within 30 days of the effect of the day of the withdrawal and recognition of the state and registration agency. The department shall cease to recognize the federal purpose of each of the apprenticeship program registered with the state apprenticeship unless at the time of the sponsor request registration of the office of apprenticeship in the event where the state apprenticeship agency is not recognized by the office of apprenticeship of the federal purpose of such recognition has been withdrawn. If no state apprenticeship of the state apprenticeship agency apprenticeship program sponsor must be requested the registration application of the office of apprenticeship in accordance with the following. 1. The office of the apprenticeship may be grant request registration for any with an interim probation for the confrontation with the recognition for the contingent with the upon with the finding of the state apprenticeship program is operating with accordance with the requirements of Part 29 CFR Part 30. The Office of Apprenticeship may find with the issuing 30 days of the receipt. If the filing with the negative, the state sponsor may be notified writing within the term of the registration. The Office of Apprenticeship has been revoked, if the program will be deregistered unless the sponsor requesting hearing of the 15 days of the request of the notice of the hearing will request for the matter of the forwarded to the Office of Administrative Law Judges for the hearing in accordance with the statute 2910. If the filing with affirmative, the state sponsor must be notified in writing within the term of registration with the Office of Apprenticeship that has been made permanently based on the compliance with the requirements for this part. If the program fails to request the registration with the Office of Apprenticeship, the written notice to these such the state sponsor must further provide the recipient to action, the action to benefit the applicable recognition of the federal purpose no longer available to participants in the apprenticeship program as of the date of 30 days after the date of the other withdrawing recognition. Such notice may also direct the state sponsor to notify within 15 days. All registered apprenticeship with the withdrawal recognition for the federal purpose effective date thereof, such withdrawal remove the apprenticeship and the covered owner any of the federal provisions applicable to the individual registration under the program recognize and registered with the Secretary of Law Labor for the federal purposes. Such notice must be directed with all the apprenticeship to refer to the Office of Apprenticeship and information about the potential transfer to the other registered apprenticeship programs. H. Where a state apprenticeship agency recognition for the federal purpose that has been withdrawn, the state must provide all apprenticeship programs, maintenance standards, and apprenticeship agreements, completion records, cancellation, suspension records, equal opportunity compliance review files, and other documentation relating the state apprenticeship program to the department. 2. Cooperate with the fully during the transition period, and 1. State apprenticeship agency without the recognition have been withdrawn under the part of the may have the recognition reinstated with the presentation adequate evidence for the failed requirements established in Statute 2913I, 2914G, and 29H. This is operating in conformity with the requirements for this part. Alright, that completes the Federal Register, Part 2, Department of Labor, Employment and Training Administration, 29 CFR Part 29, Apprenticeship Program, Labor Standards, Registration, Amendment of Regulations, and Final Rule.